Title: The Colorado School for the Deaf and the Blind presents Leaving a Legacy for Special Needs Families with Paul Mason, attorney. Our presenter, Mr. Mason, is standing in front of a flip chart. Captions are below on screen.
Hi, my name is Paul Mason. I'm a state attorney here in Colorado Springs, and I practice specifically with clients and families and help them with their transition planning. I help them with their special needs that they have, and I specialize with families with special needs or special abilities. And I just kind of want to talk to you today a little bit about what's out there and what you might need to know or be aware of, and just some things to think about. And so what I'm going to do today is a couple things. One is I'm going to go through several documents that we need to know about, and then I'm going to talk a little bit about planning and how it's important for us to think about the special ways that we do need to plan for our children, and then for our children to also plan for us when they become of age of 18 or older. So with that, I'll get started, and what I want to talk about first is a document called a power of attorney. A POA. Now, a power of attorney, there's more than one kind. A general power of attorney can allow someone to have complete access. And when we talk about power of attorney, when we talk about access, we talk about financial or legal capacity. So someone with a power of attorney, what they would be able to do is to be that person, to legally sign or act for that person. And so what we would use a power of attorney for is, let's say, a husband and wife. Husband wants to be able to go out of town or has something business trip, and the spouse needs to be able to sign for them. With the spouse having a power of attorney, they would be able to do that. Why is this important? Well, if you're not able to sign for that person and you're signed or a part of on that document or for that contract, that person wouldn't be able to sign. Think of cable bill. Either your husband puts it in place or your wife puts it in place and you try to get something changed, they want to speak to that person. It can be a very big problem if somebody becomes incapacitated. And so when you talk about power of attorneys, there's two types. There's one called a springing power of attorney and one called a standing power of attorney. A standing power of attorney, as soon as we sign the document, it stands. It means it's alive. So if I have a standing power of attorney for my wife and I'm gone, she can be me however she needs to. A springing power of attorney means upon incapacitation. Something happens and it springs to life. Things to think about. For most of the time for husbands and wives, we use a power of attorney, a standing power of attorney. For children who have maybe younger kids or adults, then what we would need to do is be able to maybe spring it to life. And so some things we want to talk about today is why it's important for parents to be thinking of this, and then why is it for children turning 18 to 21, 24 in that area. Well, if a child becomes of age, so from age 18 to 20, and they start to no longer have to be under the guardianship of their parent, it can be very important that we put a power of attorney in place for that person so that they can sign for that person. So like if I'm 18 and something happened to me, I'm in an accident or I'm not able to do something, I need for my parents to be able to sign for me. Also, if I'm the parent and something happens to me, I need either my spouse to sign or I need a backup person to sign, not just for me, but also for my dependents who might need to be able to act and have that ability to sign. Because if I'm under than 18, I can't sign a contract. My parent or guardian has to be able to sign that. So that's one thing when we talk about a power of attorney. A healthcare power of attorney, very similar to a power of attorney. And what this document does is it allows a person to make healthcare decisions for you. And thing to think about is both my spouse probably wants to make that decision or who that backup is. But if I'm a child, I need to be able to make sure I tell which parent or which parents I want to be able to make that decision for me. Now, when I say child, I mean 18 or over. If I'm a child of that the parent, because I might have one parent that I want to be able to make that decision, and the other one I don't want to make decisions. So those are the documents we want to make sure we have in place. The other document we want to place is a living will. Think of the Sanchez case out of Florida. This was the case where a young couple, she gets into an accident, and what happened was she was incapacitated. The husband spent many years trying to get her better and was not able to. And so what the husband finally made a decision was, it's time to end artificial nutrition, take her off of this vegetative state. Her parents got involved and said no. Many years went by until finally he won. They pulled out the feeding tube, a week went by, president issued a stay, tube went back in, it was another year before they could let her go. So it's important for us to be thinking about that, but also for our children. You know, children want to be thinking about, do I want to be in that place, and what if I have spouses or parents that think differently, or even grandparents? So it's something for people to be thinking about. And again, when I say children, I meant 18 or older. Another document we want to think about is and this is very important, is a document called a HIPAA, HIP authorization. HIPAA was a law passed by Congress in about '06 that said we need to protect medical information. It's very, very important. So for me, I'm going to have my wife be able to have access to my medical information. If I have children that are old enough, I would want to give them access, and maybe my parents. If I'm an 18-year-old to 24-year-old, I want to make sure my parents have access, maybe my siblings, maybe a grandparent. But we have to let people know who we want to have access to. So when we start talking about estate planning or planning for the future, these documents are extremely important to have in place, both for parents, but also for children who are transitioning from childhood to adulthood. And so I'm going to kind of put a box around those because those are documents that we're going to need. And the other thing I want to talk about transitioning from here over into planning side is the two documents. One is called a will, and the other one is a trust. And let's think about the two and what's important with the two. First, I'm going to define what a will does. One thing important that a will do is we'll define and say who do I want my guardians to be of my children. Now what we do is we ask the court and we say, hey, court, this is important to me. These are the people that I would like to take care of my kids. It's especially important if we have minor children that we list who those people will be. What it also does, it says anything that is mine, this is how I want to transfer it. But we have to define what is mine. With a will, there are a lot of things that you would think that are yours, but they don't necessarily get controlled by a will, such as retirement accounts, 401ks, IRAs, those things have beneficiaries. The beneficiary would travel outside and not travel through the will. Secondly might be a deed for a home. If me and my wife own a home, depending on how we own it, if I died, it could go directly to her. Or let's say me and my brother had a property. It could be, depending on how it's titled, it could go that way. There's also things called paid on death accounts and those kind of things. But what a will says, anything that are not those kind of properties, so let's say I have a joint bank account, that would go to however the will says. The thing to think about here, though, is minors. If I have children, and if I have children that are not of age, I can't leave them property. So a child under 21 years old, I'm not capable of leaving them property. What I would do if I left it to them, it would go into conservatorship. And that means the courts puts a big wall around it. There's someone in charge of it, not the guardian, but someone else. And they dictate how I can invest it or how I can put it to work. Most of the time, they make you put it into an FDIC insured investment. As we all know, interest rates are really low, so that can be a very problematic situation when I can't make enough money to take for my kids. So what we mostly have to do is we have to leave money for our children in trust for their benefit. And if we're able to do that, then they can still have the benefit from it, and I can pick who's going to be in charge of that. Now let's take a minute and let's talk about children with special needs or children that qualify for special needs. It can be problematic for them to have a trust where they are guaranteed or have income. So what we do is we develop a special kind of trust. And how it does is from the will or from a trust, and I'll talk about this in just a minute, what we'll do is we'll build a trust, and it's called a special needs trust. How a special needs trust works is it says anything that I may qualify, any kind of assistance that the government says, this does not disqualify me. It's not included into my assets. So when they go and you have to fill out and say, these are my assets, this isn't included. The trust specifically just states, I will supplement however I choose to supplement whatever they have. And by doing it this way, we haven't disqualified a client at all. Think of your elderly parent. I'm 85 years old, I get put into a home. In order for me to qualify to be put in the home under government assistance, I have to deplete my assets down to $2,000. If I had a supplemental needs trust, they wouldn't include that. I'd immediately qualify. Very important with kids who might have disabilities that we be able to put it together in a special way that doesn't disqualify them, but it be able to put that asset to work for them and not deplete it all the way so that they never have to worry about dying destitute. Significantly different. How these two work, the trust between the special needs trust. When we create a trust, now there's different kinds of trust. There's irrevocable trust or revocable or revocable, depending on which side of the pond you're on. But what we have is we have a situation where with an irrevocable trust, we might do it for Medicaid purposes, or we might do it for business protection, or we might do a third party or a first party special needs trust. Think of the person who gets into an accident. They get into an accident, there's a lawsuit for them, and maybe they're currently disabled. Instead of the lawsuit or the company paying them directly, they'll put it into a first party, a supplemental needs trust directly with them. And so if we had that situation, it'd be able to use for their benefit. Now, a first party, which what that would be because it came to me, is a significantly different rules than a third party. So if I'm a parent and I want to leave money for my child, they never had the money. And so it doesn't count against them. And if I leave it to them outside and put it in here when I die for my children, the rules are totally different. So that's what we want to make sure that we're doing, is specifically putting it together for their benefit. When we talk about a revocable trust or a living trust, this is a changeable. It's a relationship I have with my things, but I add it where I put it to trust. The best way I've been able to define it is when you think of Steve Jobs. If you think of Steve Jobs owned Apple. He started Apple in the early 70s. When you think of them two, you think of them together. Now, it's a little different because it's a business and not a relationship, but same kind of concept. Steve Jobs eventually got sick, and he had to step away from Apple. When he stepped away from Apple, Apple kept producing iPhones, kept producing iPads, kept doing its thing until finally he got a little better. He came back, helped them out, and then he got really sick and finally passed away, but Apple kept doing its thing. We can do the same thing with our stuff. We can create a trust now, a revocable living trust for our things. We title all our assets into the trust. We make the beneficiaries the trust. And then when something happens to me, let's say I become incapacitated, I can choose. Maybe it's my wife or maybe it's some other person, just like we did with the POA, who gets to control that. The difference is there's rules set up and there's responsibilities, and they have to follow these rules. And then when I die, I can easily pour this asset into the trust I've set up either for my spouse or for my children. And why we do that is because we can avoid probate. We can make it very, very simple to happen. And I'm going to have to create a trust. I have young children who can't take, or I have special needs children. I have to be able to create it, and I can do it in such a way that makes it very, very simple. I can name a life insurance policy. That's the beneficiary here, which will eventually pour in, be a special needs policy where it would provide the benefit for my child if something were to happen to me. This is a significantly needed planning if I have children who I need to think about taking care of or be able to provide assets for a long time. Also, I'm able to design these in such a way where my children, maybe I want them to eventually be able to take over the asset, but I don't necessarily want them at 21. If you think about it, if I had lost both my parents, and I turned 21 and someone would have handed me a checkbook, I'm pretty sure Europe might have been different. What we want to be able to do is be able to help that child transition from childhood to adulthood and not hurt them by giving money, but also use that money to help them and take care of them. So when you're thinking about estate planning or you're thinking about what do I need to do, first you're going to make sure you have the documents in place. And then you're going to need to be able to design your plan in such a way that takes care of my children. And if I have a child who's reached the age of 18 and is now becoming an adult, what I need to make sure that I'm doing is helping that child transition into adulthood and still allow me as the parent to be able to do the things that I might need to be able to do for them, but do it in such a way that allows the decisions that they want and allows it legally to be able to happen. So this is estate planning. We'll call it 101, and we'll call it in just a few minutes. And I would love to talk to you or be able to help you if I can, or if you've got any questions, feel free to reach out to me or reach out to the school, and we will do what we can to answer those questions. But again, we want to take care of the kids, and we want to make sure that we do it in such a way that helps them. So thank you.
Words appear. For more information, contact Paul Mason at the Mason Law and Planning Group, www.mlapg.com, 719-428-4495. The CSTB logo and words appear. Leaving a Legacy for Special Needs Families has been presented by Outreach Programs at the Colorado School for the Deaf and the Blind, 33 North Institute Street, Colorado Springs, Colorado, 80903. Telephone 719-578-2100, www.cstb.org, copyright 2015.